Hi, my name's Jenna Vava, and I'm going to talk about privacy. So today with technology, we're able to really reach any part of the world that we want to, just with a simple click of our mouse on our laptops or using our smartphones. For example, I recently ordered some clothing and it's being shipped from China, and it was really easy and simple, and it wasn't complicated. And so that's the same concept for businesses. Businesses are able to reach consumers that are all over the globe, and it's really easy. That makes the threat of our personal information being stolen also just as easy and accessible, as we have all of our personal information in our laptops, with emails, we have it with our social media, and so we're able to access it just as easily as someone who's trying to steal it. And so that's what privacy is. It's a right that we all have. However, it's not easy to define, especially as technology advances. The line of what's private and what's accessible sort of gets a sort of kind of a gray type of feel. So what is privacy? According to the book, privacy is the right to be let alone within a personal zone of solitude and or the right to control information about oneself. So this definition shows us two types of privacy. First right is the right of solitude, and the other right is the right to control information about oneself. So we're able to control who has access to our personal information and who doesn't. And so reciprocal obligation is what comes into play, is that as human beings, each individual should respect the other's privacy and expect others to do the same. So basically, we want to do unto others as we want them to do unto us. The golden rule. And so we want people to respect our privacy and we'll respect theirs. So how does that come into play with the workplace? And what is a privacy issue in the workplace? So a privacy issue in the workplace is when there's a conflict between the employer and employee in the definition of privacy. So for the employer, they have a fundamental right to protect the interests of the company. However, the rights of the employees are that they are able to protect what they feel are wrongful intrusions into their personal lives. So when there's a conflict in the workplace, it's typically among this conflict definition between employer and employee. So there are three ways that privacy is protected here. It's the Constitution, federal and state statutes, and common law, which are decisions that are made by courts through other previous cases. And so the Electronic Communications Privacy Act of 1986 prohibits unauthorized access of stored communications and also of communications that are in transit. So the main goal of this act was to punish monitoring of third parties. It doesn't mean that the employer doesn't have access to communications. They are allowed to intercept these communications when consent is granted, but it's to help keep the chain within the business. So that's where monitoring comes into play. So monitoring is sort of a right that employers have to monitor their employees so that nothing unlawful is performed or that employees are behaving correctly according to their contracts. So as a company, you want to have a good look to the outside. So if an employee is acting out of turn, and that in turn will provide a negative look for the company. So they have a right to sort of monitor their employees. So employees must be informed that there's monitoring in place. So it could be as email monitoring or electronics monitoring, that the employers are allowed to have access to that information. Or many places will also provide sort of a drug testing before employment. So the issue between rightful monitoring and a violation of privacy is that thin line, especially with today. So, a case about privacy and a privacy issue is the City of Ontario, California versus Kwan. And so this case was police officers of that department. They filed against the higher ups of that police department because their text messages were being read. So they felt that their Fourth Amendment rights were violated. And so the issue was that these text messages were on a work-related item. However, the police department had a general electronics policy, but they didn't have a policy specifically for text messages on the work-related items. So because there wasn't a specific policy, the employees felt that their privacy rights were being violated, and they felt an intrusion of privacy because the higher-ups were taking their text messages and reading them. So the result of this case was because the messages were on a work-related item, it was not a violation, and it was a reasonable intrusion. So this case, though, revealed how privacy in electronics are difficult to define within the definition of the Fourth Amendment and just in general as well. To what extent do we allow privacy on work-related items? So another case example is Steingart versus Loving Care Incorporated. So what the issue was that communications were on a company-related laptop. So all of the employees had communications with their clients through the laptop. However, what the issue was that the company itself failed to inform their employees that all email messages were being captured by a software. And so anything personal, such as logging into your personal email and sending an email from your company laptop, that was also being captured and sent back to the company for being monitored. And so that's where the court ruled that that was an invasion of privacy. Although they have a policy in place about email communications, they did not inform them that also personal items were being monitored as well. So that makes you kind of wonder, so how do courts treat monitoring legally? Like, what basis do they have when they have privacy issues come into their courtroom? So telephone calls. So state law requires notice to parties. So you've probably heard on the phone that this phone call is going to be recorded for legal purposes. So that's a requirement by the state law. Federal law allows employers to monitor without notice, but if the call is personal, the employer must stop immediately. With email, employers can monitor whether they say they have a monitoring policy or they say we're not going to check it. They have a right to check it. However, if it's a password protected, employers do have to tread more carefully, as it could be a personal account just being used at work. So they have to be a bit more careful, and so employees have a higher expectation for their employers to respect that right of privacy. With the internet being accessible just as easy now, if the employer provides the equipment and the access, they have the right to track and review internet use. So companies in general, though, they do have to collect a certain amount of private data. Like if you apply for a job application, they have to know your phone number, your address, they have to know your social security number for a possible background check as well. And so what was created was called the safe harbor exception. So this is to protect the private data that is collected. And so there are many requirements for the safe harbor exception. So one requirement would be the clear notice about the personal information collected. So that means that the company is very clear about what they're collecting so that the person who's giving it knows, so that they're not caught by surprise about what they're giving or being asked to be given. Employees also have the choice to not participate. If they don't feel comfortable sharing it, they have that right to say, I don't want to share it. The transfer of information only to firms with the same level of protections. So what that means is that if the personal information must be transferred to another firm, then that other firm has to have the same level of protections put in, otherwise might be regarded as not safe. So another requirement would be access of information is only for the purpose of why it was gathered. So they can only gather information for a certain purpose. They can't just gather the information just to have it. And so also the provider of the information has access to the information gathered, and they have the ability to correct anything wrong. That way nothing is misinterpreted. So when is employee privacy violated? So there's two ways employee privacy can be violated. The first is the employers infringe upon personal decisions not relevant to employment contract. And the second way it's violated is personal information not related to the contract is collected, stored, or used without consent. So technology and privacy, how does that work? So there has to be some sort of distinction between work and personal use of the technology, especially if it's the same thing. And also there's accessibility issues. So a lot of people work from home now, and that could be a big issue of what can the employee take home to work at the in-home office, and what rules have to be set there, and also what rules for the employer to get that information as it's coming from a private place. So that just places higher expectations for both the employers and the employees. So obviously businesses have to have some sort of monitoring system in place, but to what extent do they have to do it? There's 3 reasons why businesses should limit monitoring. First is that it can create suspicious and hostile workplaces. Being watched all the time can cause people to feel suspicious and think that no one trusts them. Second reason is it can constrict effective performance. So the idea of being watched all the time can provide a bit more stress and pressure on the employee. And so then the last one is employees can claim monitoring as a violation of their right to privacy. So how should this balance be maintained? So it's a thin line, it's a gray line. So there's a set of regulations that workplaces should take into account that can benefit both sides. So they shouldn't monitor in private areas such as a restroom, and it should be limited to the workplace itself and not outside the workplace. Employees should be able to have the access to the information that's being monitored, and they should always be given advance notice. So if personal information has to be gathered, it's only in the interest of use of the business, and it's only related to the job and nothing more. Employees must agree about the disclosure of information gathered, and employers are prohibited from discrimination based on off-work activities. So in conclusion, privacy is a difficult line to tread. It could easily become an ethical issue. However, if companies can maintain good communication, they can appear as acting within ethical standards for both employees and people looking in.